Thousands of black women across the country are joining a class action lawsuit linked to a popular hair product.
Yeah, this is significant. The women all say they were diagnosed with cancer after using hair relaxers made by a dozen companies, including Revlon and L'Oreal. The lawsuit was launched in October of 2022. It was days after a study by the National Institutes of Health found a connection between the use of chemical hair relaxers and uterine cancer. The lawsuit claims many of the hair straighteners are overwhelmingly marketed to women of color. Now, Revlon released this statement in response to the report and the lawsuit, saying in part, quote, "While we do not believe the science supports a link between chemical hair straighteners or relaxers and cancer, we remain open to evaluating further studies and always adhere to all regulations."
Joining us now in Studio 57 is Mike Spector. He's a U.S. corporate crisis correspondent at Reuters and the co-author of an investigative piece on these lawsuits. Good to have you with us, Mike. First of all, is the NIH study enough to prove culpability in a court of law?
So the NIH study didn't show that use of these products caused cancer, but what it did find is that women who frequently use these hair straightening products were more likely to develop uterine cancer than those who did not. And that is enough for plaintiffs' lawyers all over the country to spend millions of dollars on advertisements, recruiting clients to file lawsuits. And we've seen an explosion of lawsuits filed since this report was released last year.
And we just saw the numbers there of how many went on to develop uterine cancer compared to those who didn't use these relaxers. What type of cancer are we talking about? And how many of those who got cancer are black women? Because this is a cornerstone of the culture to some extent, what women go through to straighten their hair.
So for the most part, there are a variety of conditions that have cropped up here, but for the most part, we're talking about uterine cancer. And this NIH study noted that black women more frequently use these products than others. And this is something that's been really wrapped, it's kind of joined traditional product liability claims with civil rights issues, which we could probably talk about in a second. Ben Crump, famous civil rights lawyer who represented the family of George Floyd, as you recall, the man murdered by a Minneapolis police officer in 2020. He's involved in this litigation and actually with another lawyer filed the first hair relaxer lawsuit after this NIH study was released.
Well, on that, let's dig a little bit deeper, because the legal claims assert that there is not an allegation of racial discrimination. But at least one high-profile attorney for the plaintiff says that the cases can be viewed as essentially a civil rights issue. These are black women. They have cancer as a result of this. How does all of that impact what the jury ultimately and the judge needs to ascertain?
That's right, Lana. So the civil rights issue comment you were just talking about came from Ben Crump.
Right.
Which he told us. And as I said a second ago, you sort of have two buckets here that sort of collide. You have, on the one hand, traditional product liability claims, and the success for these women in this litigation will hinge on, can they demonstrate that the products were harmful, that they caused disease, right? And that the companies knew about this and failed to warn them. Those claims, as you mentioned, don't have a racial discrimination or civil rights component to them. However, Ben Crump and other lawyers point out that the women who've used these products have used them for decades and have used them in the context of racial discrimination. We had so many women who told us the same story about being teased on the playground as young girls, saying, your hair looks like cotton, and this feeling, and even in their own communities, that they felt like they had to conform to a certain standard of beauty. So you can imagine that if Ben Crump or another lawyer, when we see a trial, maybe not until 2025, this could go on for a while, but in a trial, you can imagine a lawyer, even though the claims themselves don't have a racial discrimination component, making that argument to a jury so that that is in the jury's mind when they're looking at these specific product liability claims, that like, oh yeah, these specific plaintiffs, it comes against a contextual backdrop of racial discrimination. We talked to a woman who was born in 1954, right? Brown v. Board of Education, and suffered discrimination in the schoolyard.
Well, certainly there's so much here for us to continue to unpack and continue to watch as this case goes to trial. Mike Spector, thank you.
Thank you. Good to be with you.